Is the pharmacist here? The one in charge?
You're speaking to her. I'm the pharmacist, and I run this place.
So you actually own this pharmacy?
Yes, 4 years now.
All right, whatever. I need those records now.
And like I already told you, those records are protected under HIPAA. I cannot legally show them to you.
Officer Daniel Mercer had walked into countless businesses over the course of his career, but none of them would come back to ruin him the way this small, independent pharmacy in Tacoma was about to. He entered the building with the same casual arrogance he carried everywhere, a kind of slow, deliberate confidence that said he expected compliance before he even spoke. That day, though, he was facing someone far better prepared than he could ever imagine. Dr. Lillian Harper, the supervising pharmacist and owner of the store, looked up from her workstation when the door chime rang. At first glance, she seemed like any other professional behind a pharmacy counter, focused, organized, deep in paperwork. What Officer Mercer had no way of knowing was that the woman standing there wasn't just a pharmacist. She was a fully licensed attorney with advanced training in healthcare privacy law. She had gone to law school not to practice in a courtroom, but to ensure no one, especially not a police officer, ever put her in a position where ignorance could be exploited. Her staff respected her. Her patients trusted her. And Mercer was about to find out exactly why. Dr. Harper had purchased the pharmacy nearly 4 years earlier, after leaving a large corporate chain where she'd worked for 7 years. She'd witnessed the same disturbing pattern play out too many times. Law enforcement walking in with vague investigations, demanding access to patient histories, surveillance footage, or controlled substance logs without proper authorization. Most pharmacists weren't trained to question these demands. Many complied simply because the badge intimidated them. Lillian refused to be one of those people. Instead of complaining, she enrolled in law school. For 3 exhausting years, she studied constitutional law, regulatory compliance, privacy statutes, and the intricate structure of HIPAA protections. She passed the bar exam on her first attempt, and then, instead of becoming a practicing lawyer, she went straight back to pharmacy work, now fully armed with the knowledge she needed to protect her patients from unlawful intrusion. Her pharmacy served around 250 to 300 people daily, many from some of the most vulnerable parts of the community. People dependent on HIV medication, individuals in various stages of addiction recovery, patients dealing with severe anxiety, bipolar disorder, depression, or hormone therapy. Patients whose jobs, families, or safety could be jeopardized if their medical information was accessed improperly. Dr. Harper understood this better than most. Every record behind her counter represented a life that could be destroyed if the wrong person gained access. This was personal to her. Privacy wasn't just a legal requirement, it was an ethical duty. So, when Officer Mercer walked directly to her counter and declared he needed access to certain records, she recognized the situation immediately. A fishing expedition dressed up as an official investigation. Mercer offered only vague phrases like suspicious activity and ongoing inquiry, statements that carried zero legal significance but were designed to pressure someone into giving up information without asking questions. He expected the intimidation tactic to work. It usually did. But Lillian wasn't most people. When she refused, calmly and professionally, Mercer leaned his weight onto the counter and lowered his voice, warning her that refusing to cooperate with a police inquiry could result in obstruction charges. It was an empty threat, but Mercer had used it before. People usually backed down to avoid trouble. Lillian didn't so much as flinch. She simply reminded him, again, that federal law prohibited her from releasing protected health information without a warrant or court order. She quoted the statute numbers from memory, her tone steady and controlled. She even read his badge number aloud, not as a threat, but as documentation, a quiet signal that she understood the process far better than he did. Customers browsing cold and flu aisles had started noticing the tense atmosphere. A couple paused their shopping to look toward the counter. One of her pharmacy technicians, Devin, a meticulous young employee who respected Lillian deeply, positioned himself near the workstation where he had a clear view of the encounter while pretending to label bottles. Overhead, 2 security cameras recorded the entire exchange in flawless clarity. They captured the officer's posture, his tone, his escalation attempts, even the subtle shift in his expression when he realized intimidation wasn't working. Mercer, annoyed and embarrassed, escalated again. This time he claimed he needed to conduct a comprehensive inspection of the pharmacy, implying that non-compliance would open the door to a deeper investigation. It was a transparent attempt to create a pretext to access everything behind the counter. But Dr. Harper dismantled that tactic instantly. She explained that pharmacy inspections fall under the Washington State Department of Health and the State Board of Pharmacy, not the Tacoma Police Department. Her facility had passed an inspection just 8 weeks earlier. Mercer had absolutely no authority to inspect anything in that building. His frustration grew. When he rested his hand near his radio, it wasn't subtle. It was a physical threat, an implication that he could call backup, escalate the situation, create chaos, or intimidate her further. But she didn't budge. She didn't raise her voice. She didn't demonstrate fear. Instead, she clearly laid out the legal violations occurring in real time. By entering without a warrant, demanding confidential patient information, issuing baseless threats of obstruction, and falsely claiming inspection authority, he was violating federal regulation, state law, and constitutional protections. And the cameras had captured every detail. The moment she mentioned legal action and formal complaints, Mercer froze. The gravity of what he had done hit him. He wasn't dealing with a confused employee. He was dealing with someone who knew the law better than he did, and who had evidence on her side. He muttered that he'd return with the proper paperwork, though they both knew he didn't have any grounds to obtain it. Lillian simply responded that he should call ahead next time to avoid disrupting patient care. He left without looking at any of the customers watching him go. But the story didn't end there. Lillian backed up the security footage in 3 separate locations, 2 encrypted drives and a secure cloud server. She then contacted her attorney, a healthcare law specialist named Elaine Kim, who had advised the pharmacy for years. When Elaine reviewed the footage, she told Lillian the situation was far more serious than just an overreach. It was a textbook civil rights violation. Elaine insisted they file a formal complaint with the department immediately and prepare for a possible retaliation attempt. Over the next 2 days, they assembled an airtight legal complaint. It documented the violations chronologically, referenced the specific statutes breached, and included time-stamped screenshots of Mercer's behavior. The complaint was nearly 14 pages long, with appended exhibits. It was submitted to the Tacoma Police Department's Office of Professional Standards. Within 24 hours, it landed on the desk of Lieutenant Carla Mendoza, Mercer's unit supervisor. She was known for being strict, fair, and intensely focused on accountability. When she saw the footage, her expression reportedly went cold. She summoned Mercer into her office, made him sit down, and played the entire recording in front of him. She didn't interrupt, she didn't speak. She watched his confidence drain as the evidence stacked against him second by second. When the video ended, she asked him whether he had a warrant for any of his demands. He said no. She asked whether he had the authority to conduct a pharmacy inspection. Again, no. She asked whether he threatened a civilian for obeying federal law. He hesitated, then admitted he had. Her response was immediate: suspension, pending investigation. Badges and weapons turned in on the spot. Internal Affairs spent the next several weeks digging through Mercer's recent cases. What they discovered was a pattern. He had requested protected financial, medical, and security information multiple times without proper authorization. In each case, the civilians complied because they did not know they had the right to refuse. Lillian's case was the first where someone pushed back and documented everything. The investigation recommended termination. The city accepted the recommendation. Mercer was fired for cause, but the fallout didn't stop there. With Elaine Kim's guidance, Dr. Harper filed a federal civil rights lawsuit under 42 U.S.C. San 1983 against both Mercer and the department. The city reviewed the footage, the complaint, and the investigation findings. They knew a jury would destroy them. They settled the case quietly, reportedly for a mid-six-figure amount. More importantly, the settlement forced the department to overhaul its training on privacy law and handling of healthcare information. Officers were required to complete new certification modules on HIPAA compliance, constitutional boundaries, and proper documentation. Lillian even reviewed the training drafts before implementation. Her story spread through the community quickly. Patients felt safer. Other pharmacists reached out to learn how they could protect themselves. News outlets covered the case, framing it as a rare example of a civilian who knew the law well enough to shut down unlawful police pressure in real time. Officer Mercer never worked in law enforcement again. Every agency he applied to saw the termination report and quietly declined. Dr. Harper, meanwhile, continued running her pharmacy with a renewed sense of purpose. She paid off her student loans. She started a fund to help healthcare workers seek legal help in similar situations. She even testified before the state legislature on privacy protections in healthcare environments. In the end, her quiet refusal to yield didn't just protect her own patients. It forced systemic change, set a precedent, and reminded everyone watching that rights only matter when someone is willing to stand firm and defend them. The weeks following Mercer's termination were far more turbulent for the Tacoma Police Department than anyone internally expected. Most disciplinary cases were quiet, contained, and easily buried under bureaucratic paperwork. But Dr. Lillian Harper's complaint had been constructed so thoroughly, supported by such airtight documentation, that it triggered a chain reaction through multiple oversight units. The internal affairs investigation that began with a single pharmacy visit expanded outward as investigators reviewed Mercer's previous case files. They weren't looking for trouble. They simply had to verify whether his behavior at Harper's pharmacy was an isolated lapse or a pattern. What they found was a pattern so consistent that it shocked even senior command staff. There were additional cases, dozens of them, where civilians had complied with demands that violated privacy laws, merely because they were intimidated or unaware of their rights. None of those individuals had filed formal complaints. Internal Affairs realized the department had unknowingly allowed unlawful information gathering to become normalized within Mercer's unit. As news circulated internally, it quietly rattled officers who had worked with him. Some remembered him as aggressive but effective. Others recalled uncomfortable moments when he pushed boundaries they didn't fully agree with, but no one had expected his behavior to surface so publicly or with such damning clarity. The department's legal division began preparing for the worst-case scenario, a chain of civil litigation if other civilians realized they too had been coerced. The department wasn't just dealing with one disgraced officer. They were grappling with the exposure of long-standing systemic weaknesses. In meetings, commanders debated how to contain the fallout. Lawyers warned them that ignoring the situation would lead to catastrophic legal liability. Administrators worried that addressing it too aggressively would spark resentment within the ranks. It was a problem with no easy solution, and the spark had been a woman who simply knew the law better than the officer confronting her. Meanwhile, Dr. Harper's life changed in quieter, more personal ways. Patients who had always trusted her now trusted her even more fiercely. Some began telling her stories about situations they had never disclosed to anyone. An older man shared that decades earlier, an employer had found out about his antidepressant use and fired him. A young mother admitted she had avoided filling her anxiety medication for years because she feared the information would somehow reach her abusive ex-partner. People were relieved to see a healthcare professional actually protect their confidentiality with conviction. This wasn't abstract policy to them. It was safety, dignity, and survival. But there was also a sense of unease among her staff. Devin, her technician, admitted one morning that he had trouble sleeping after rewatching the footage during the legal review. He told Lillian he felt guilty for not stepping in somehow, even though she insisted he had done everything right. Another pharmacist on staff, Miriam, confessed she had been terrified the officer might escalate physically. They all understood how quickly a calm situation could spin into chaos when someone in authority felt threatened or embarrassed. Lillian reassured them as best she could, reminding them that awareness and preparation were their greatest tools. Still, she could feel the subtle shift in the atmosphere. Her staff had seen how fragile safety could be when the law was misunderstood or misused. Elaine Kim, Lillian's attorney, continued negotiating with the city. Her approach was calm but unyielding, much like Lillian's. She pushed for stronger reforms, not just a payout. She argued that what happened in that pharmacy represented a larger failure that needed structural change. The city resisted at first. They didn't want to commit to department-wide retraining or new oversight procedures. It would be expensive and politically sensitive, but the strength of the evidence gave Elaine leverage. The city's leaders knew a single trial could expose flaws that were far more damaging than implementing reforms. They eventually relented, and the settlement became a package deal: compensation for damages, policy revisions, mandatory training modules, and new supervisory approval requirements for any law enforcement request involving protected information. The training materials themselves became a point of debate. the department initially drafted something generic and superficial, little more than a slideshow about privacy laws. Elaine insisted this wasn't enough. She wanted something meaningful, something that would prevent future violations, not just check a compliance box. She arranged for Lillian to review the content personally, and together they rewrote entire sections. They added real examples, legal citations, and case scenarios that officers would realistically encounter. Lillian emphasized the importance of officers understanding that privacy laws weren't roadblocks. They were boundaries meant to protect civilians and officers alike. She included explanations of how violations could jeopardize investigations, undermine prosecutions, and expose the department to lawsuits. She wasn't doing it out of resentment. She was doing it because she believed deeply in accountability and education. When the training program launched, officers had mixed reactions. Some appreciated the clarity. It helped them understand exactly what they could and couldn't request legally. Others were annoyed, interpreting it as a restriction on their investigative abilities. A few quietly blamed Dr. Harper, saying she had overreacted. But most understood that the days of casual overreach were ending. They might not have said it aloud, but they knew the department had been cutting corners for too long. Outside the police department, local media began picking up fragments of the story through public records requests. An article eventually broke in a regional paper describing privacy violations within Tacoma's narcotics unit. This article, without naming Lillian directly, highlighted a pharmacist who had stood firm against unlawful demands. The story rapidly gained traction online because it resonated with so many people who had been pressured by authority figures. Within days, national outlets reached out for comment. Lillian declined most interviews, choosing to keep the focus on systemic reform rather than personal recognition. When she did speak, it was measured, focused, and rooted in factual explanation, not sensationalism. Ironically, the pharmacy's business increased. People from across the city began transferring their prescriptions to her store, explaining that they simply felt safer under her care. Parents came in with teenagers to explain why privacy mattered. Elderly patients told her she reminded them of providers from decades ago who acted with unwavering integrity. Lillian didn't view any of this as victory or praise. She saw it as proof of how deeply people yearned for trustworthy systems that respected them, not exploited them. While she was becoming a quiet symbol of lawful resistance, Mercer faded quickly into obscurity. After his termination, he applied to departments in surrounding counties, but none would take him after reading his disciplinary file. Some interviews ended after 5 minutes. Others rejected him before speaking to him because the internal affairs report circulated informally through professional networks. Officers talk, chiefs talk, HR directors talk. Word spread that hiring him meant inheriting a potential liability. He eventually stopped applying altogether and retreated from public life. For many, that might have seemed harsh, but the truth was clear. His downfall was not caused by one mistake. It was caused by years of disregarding rules he was sworn to follow. 3 months later, Dr. Harper received an invitation to speak at a statewide healthcare conference. The organizers wanted her to give a talk on protecting patient privacy in the face of unlawful demands. She initially hesitated. She disliked attention and preferred staying behind the pharmacy counter. But Elaine encouraged her, insisting that her insights were valuable, especially because they came from someone who had lived through the situation, not just studied the theory. Lillian eventually agreed. The talk she delivered stunned the room. She didn't dramatize the encounter. She didn't demonize law enforcement. Instead, she explained clearly how misinformation, fear, and lack of legal knowledge created vulnerabilities. She urged healthcare professionals to educate themselves, document everything, and stand firm when confronted with unlawful demands. She walked them step by step through what proper procedures should be, what red flags to look for, and how to handle intimidation. By the time she finished, she had received a standing ovation. Multiple hospitals immediately requested she train their staff. Her presentation became a widely shared internal resource across state healthcare institutions. Her influence expanded beyond healthcare. A local university's criminal justice program invited her to speak to future officers about privacy boundaries and constitutional rights. She accepted, believing that change could only last if new officers learned things correctly from the beginning. Many students later reported that her lecture was the first time they understood how difficult and delicate privacy issues were in real investigative work. One student even told her after class that her talk changed his entire view of community policing. Meanwhile, the Tacoma Police Department completed their implementation of the new training protocols. Supervisors began strictly enforcing documentation requirements for information requests. Officers now had to justify their requests in writing, citing specific legal grounds. For the first time, many realized how often they had relied on shortcuts simply because they were convenient. The revised system created friction at first, but eventually officers accepted it as part of professional practice. The ripple effect grew even further. State legislators began reviewing existing privacy laws to determine whether they needed strengthening. Advocacy groups cited Lillian's case and testimonies about overreach and misuse of authority. Health professional associations across the country began updating their internal training modules. Lillian had never intended to influence policy or reshape institutional behavior. She just wanted to do her job and protect her patients. Yet her simple refusal to be intimidated had become a catalyst for statewide reform and national awareness. Months passed, but the memory of that day at the pharmacy never fully faded. Sometimes Lillian found herself replaying the scene, not out of fear, but as a reminder of how close things had come to spiraling into something dangerous. She also sometimes replayed it to remind herself that knowledge, calm, and preparation were powerful shields. She had stood alone that day, yet in doing so, she had protected thousands. As winter settled over Tacoma, the aftermath of the pharmacy incident continued to expand in ways no one had anticipated. What had begun as a single unlawful demand for records had grown into a conversation, stretching from community meetings to state oversight boards. Dr. Lillian Harper found herself in a position she never sought, but accepted out of responsibility. She had inadvertently become a reference point in discussions about civil rights in healthcare settings. The strangest part, to her, was that she had not fought anyone. She simply refused to break the law. Yet, somehow, that simple refusal had exposed a fault line that ran through the foundations of both healthcare compliance and police procedure. The civil rights lawsuit she filed progressed quietly following the settlement, mostly involving procedural matters and documentation exchanges. Elaine Kim, her attorney, kept Lillian updated on every development, though many updates were routine. But, one particular update late in the winter sent shockwaves through the city government. Multiple other individuals, upon hearing parts of the story through rumors or early news reports, contacted attorneys about similar experiences with law enforcement. At first, it was just 2 or 3 calls. Then it became a dozen. Then, as more internal documents surfaced through public disclosure requests, over 24 potential complainants stepped forward. Some of these people had been coerced into giving up private medical records. Others had been intimidated into allowing inspections that officers had no authority to conduct. Many did not realize until hearing Lillian's case that the actions taken against them were violations. Some had lived for years believing they had no right to question an officer. Now, suddenly, they understood that the law had been on their side all along. It was both empowering and infuriating. Elaine handled these developments with strategic precision. She knew the city would try to prevent a wave of lawsuits from forming, but once people realized they had legal standing, there was only so much the city could do. Some of the individuals forming these complaints asked if Lillian could speak with them directly. She declined, not because she didn't care, but because she understood the legal and emotional complexity involved. She didn't want to risk influencing their statements or giving advice outside her professional boundaries. Still, she felt the weight of their stories. She realized her encounter with Mercer represented only a fraction of what had been happening quietly for years. Meanwhile, her pharmacy continued to evolve. The increased patient load brought challenges. She had to hire another technician and expand her inventory to keep up with demand. But with growth came something else, a deeper sense of trust. Patients would lean in a little closer when speaking to her at the counter, not because they feared eavesdropping, but because they believed she truly cared about their well-being. They were right. Her staff also grew more confident navigating difficult situations. They attended additional training Elaine helped facilitate, and soon they could identify improper requests instantly. They developed protocols, what to record, what to document, how to store evidence, and how to respond calmly without escalating tension. Lillian wanted her staff to feel safe and equipped, and she succeeded. Yet, despite the newfound stability, she still carried a quiet tension inside. Every time the pharmacy door chimed unexpectedly, she felt a faint alertness, a subtle readiness. Trauma doesn't always appear as fear. Sometimes it surfaces as heightened awareness. She didn't dwell on it, but she noticed it. She also noticed how quickly the tension disappeared when she saw a regular patient enter, or a parent carrying a child, or a teenager coming in after school. The pharmacy was a safe place for her community, and she had to maintain that energy even when the past tried to intrude. During that same period, the Tacoma Police Department's leadership faced increasing pressure to show tangible reforms. The department's public relations team drafted statements promising improved training and better oversight. These statements were met with skepticism from the public, who had become increasingly aware of systemic issues within narcotics units across the country. The department knew they needed to do more than issue press releases. They needed to demonstrate meaningful change. One of the most significant internal shifts occurred when Chief Renata Lawson quietly commissioned a full review of information gathering practices within the department. She wanted to understand the scope of the problem. The review found that although Mercer's behavior was among the most egregious, he was not alone in misunderstanding or disregarding privacy boundaries. Several officers had unknowingly obtained information improperly, not maliciously, but because they had never been adequately trained on the legal distinctions between permissible inquiries, administrative requests, and protected information. This revelation embarrassed the department's leadership and validated what Lillian and Elaine had been arguing. Systemic neglect, not individual misconduct, had created the environment where Mercer's behavior could flourish unchecked. The chief instituted new policies requiring all officers to participate in biannual privacy law refresher courses. She also implemented mandatory legal briefings for new hires, ensuring they entered the department with a foundational understanding of constitutional restrictions on their authority. Supervisors were given additional responsibilities. Any request for protected information now required formal review and written justification. The union resisted at first, arguing that the new policies slowed down investigations, but the chief held firm. She knew that speed meant nothing if the methods used destroyed public trust and violated rights. The public response shifted from outrage to cautious optimism. Some community members attended town hall meetings, speaking about their own experiences with law enforcement and privacy violations. Others expressed gratitude for the reforms, even if they believed they should have been enacted sooner. In those meetings, Lillian was often mentioned as the catalyst, though she rarely spoke publicly unless asked by reform groups or professional organizations. She wanted to remain a pharmacist first. Her identity was rooted in service, not activism, but she accepted that sometimes service meant stepping beyond one's comfort zone to address a larger societal need. Meanwhile, new developments arose in the state legislature. A senator from Western Washington introduced a bill strengthening protections around patient information, requiring stricter penalties for unauthorized access, and mandating that any law enforcement request for medical records be documented in a statewide system. The senator cited recent events in Tacoma without naming Lillian directly. Lawmakers debated the proposal intensely. Privacy advocates supported it wholeheartedly. Some lawmakers pushed back, claiming it hindered criminal investigations. But ultimately, the bill gained bipartisan traction because it addressed a gap no one could deny anymore. Healthcare providers across the state testified in support of the bill, sharing examples of ambiguous or legally questionable encounters with officers. Lillian, though reluctant to step into a political arena, provided written testimony explaining the practical realities pharmacists face and the need for clearer guidelines. Her testimony was factual, concise, and deeply persuasive. As her influence grew quietly, a new dynamic emerged inside the pharmacy: mentorship. Younger pharmacists and pharmacy students began reaching out to her for advice. Some traveled from different parts of the state to meet her. They wanted to understand how she balanced legal knowledge with patient care. They wanted to learn how to navigate difficult conversations with law enforcement without succumbing to fear. Lillian never intended to become a mentor, but she accepted the role with humility. She emphasized that she was not a hero, just a professional doing her job properly. But the students saw something else, a demonstration of courage grounded in knowledge. They wanted that same confidence. She taught them the importance of documentation, clarity, and unwavering adherence to ethical standards. One day, nearly 6 months after the initial incident, a young pharmacy resident named Jordan approached her in tears. He explained that his previous employer had fired him after he refused to disclose confidential patient information to an officer without proper authorization. He had believed he did the right thing, but losing his job had shaken him. After reading about Lillian's case, he realized he wasn't alone and that he had acted lawfully. She listened to him without judgment, offering validation and guidance. For him, that moment restored faith not only in himself but in the profession. As the year progressed, the pharmacy became busier than ever. Lillian expanded her services, implemented new patient care programs, and deepened her community engagement. But even as she thrived professionally, the incident with Mercer remained a quiet reminder of the world's fragility. She didn't fear law enforcement. She feared ignorance, on both sides of the counter. That fear became motivation. It pushed her to continue educating, advocating, and leading by example. Officer Mercer, now unemployed and facing mounting legal costs, disappeared from public life. His downfall was not dramatic. It was silent, slow, and relentless. The professional world he once belonged to no longer wanted him. Some former colleagues pitied him, others privately blamed him for the department's new restrictions. He avoided media inquiries and lived a reclusive existence outside city limits. His story became a cautionary tale told in training sessions, the price of disregarding the boundaries of your authority. In contrast, Lillian's story continued evolving into something larger than she ever intended. Community leaders recognized her as a model of lawful resistance. Healthcare organizations referenced her case in training manuals. Law schools used the incident in case studies. Police departments in other states contacted her attorney to request guidance on revising their own privacy policies. Lillian often wondered how her life might have unfolded if Mercer had walked into her pharmacy with a warrant, or if he had simply respected the law. The encounter might have ended in minutes. No legal action, no reform, no publicity, just a routine interaction. But that wasn't what happened. Instead, his missteps collided with her expertise at the exact moment when change was desperately needed. And in the quiet moments before closing the pharmacy, when the last patient had left, the security system had armed itself, and the fluorescent lights hummed faintly overhead. Lillian would sometimes reflect on the strange path her career had taken. She hadn't chosen to become a public figure. She hadn't chosen to be a catalyst for statewide change. All she chose was to do the right thing at the right time. Everything else flowed from that choice. She realized something profound. Protecting people didn't always look like heroism. Sometimes it looked like a calm refusal. Sometimes it looked like saying no, even when it was uncomfortable. And sometimes it meant standing alone until others realized they didn't have to.